I think we can get started now. Uh, Hello, everybody. Good afternoon, or at least good afternoon where I am on the East Coast. Um, my name is Peter Zimroth. I'm the director of the Center on Civil Justice here at the NYU Law School. This is the center's first digital conference, and I'm very glad that you all could could be with us here today. I am particularly happy that our dean, Trevor Morrison, is here with us. He'd like to say a few words of welcome, but before that, I just want to tell you just a very little about the dean's very distinguished career that he has had and continues to have. Before becoming the dean at the law school, Trevor served as an associate general counsel to President Barack Obama and was a law professor at Cornell, then at Columbia Law School. He also served in the Office of Legal Counsel. He clerked for Judge Betty Fletcher on the Ninth Circuit and Justice Ruth Bader Ginsburg on the Supreme Court, and he continues that illustrious career as our dean. He is, I will tell you, I'm very proud to be a member of that community that Trevor oversees, and he's done an absolutely fabulous job in not only in general, but particularly in this very trying time. Trevor?
Thank you, Peter. That's a very kind introduction, and makes me think I should say nothing at all for fear we can only go down from there. But let me just not delay the beginning of these proceedings too very long. I just do want to welcome everyone. Thanks to all of you for joining us today from wherever you are. And special thanks to Peter and David at our Center for Civil Justice, to the faculty co-directors of that center as well, and to the terrific board that advises the center. It's been around NYU for almost exactly the same amount of time that I've been around NYU, and I've really been amazed to watch the fantastic work that the center has done over those about 7 years. And I'm really pleased that it's in a position to convene this very timely conversation. Talking about dispute financing is an important topic at any time, but as I think this afternoon's panels will reveal, there are really important intersections with that issue in our current moment, and look forward to learning a lot from the panelists. So I want to thank all the panelists for making time to be with us in this Zoom environment this afternoon. And thanks again to everyone else for joining us. And I wish you a very good afternoon conference. Peter, back to you.
Thank you, Trevor. So for those of you who are new to the center's events, our center is, just to tell you a little bit about the center, is dedicated to the study of the civil justice system in the United States and how it can fulfill the purposes of the civil justice system. We study the civil justice system, but we have no other agenda. The only agenda is our mission is to improve the United States civil justice system. Some of our, Trevor mentioned our board, some of the most distinguished judges, lawyers, and scholars in the country sit on the center's board, and roughly equal number of plaintiffs and defense lawyers. So one of the center's projects is an attempt to compile and analyze information on the dispute financing industry. And the history of that project is that in the fall of 2015, the center hosted a very successful conference on litigation funding, exploring both the academic and the practical thinking about issues facing what was then a new and growing area of law. And at the conference, many of the participants, including industry leaders and academics, noted that there was a need for a neutral body to collect and make available material about the industry. Because information on dispute financing has been scarce and dispersed, without such a collection of materials, judgments continue to be made about the industry by both advocates and and critics through anecdote as opposed to information. Now, in response to this need, the center set about to create a dispute financing library, which launched in April 2019. And since then, the center has been committed to making sure that information about the dispute financing industry is readily available, both to those in the industry and to the public. And so this conference is a very, very important part of that mission. Before we begin the first panel, I do want to say, just hold on one second. Yeah, I want to say that because we have CLE pending, there are certain rules for the conduct for credit, and the moderators will be announcing a code at the beginning and at the middle and at the end of each panel. And you folks should write down that code. David, are you on? No. Okay.
Yes, I'm here.
Okay. So will you explain how that works, and then I will introduce the first panel.
Yeah, absolutely. So the way this works is 2 times during each of the panels, the moderator will say a code. You will need to write down that code. When the conference is over, we will send out to everyone who registered evaluation form, and also a separate form where you have to write in those codes and say that you were there. Once you've sent those forms into us, we'll send it along to the CLE people to make sure you get your certificates. So it's a relatively simple process. Just write down the code either on your computer or by hand. You'll get 4 of them total over the course of the conference, 2 during each panel. And we will then send you the document you need to fill out after this event.
Okay, and then also, David, could you explain to everybody how they will be asking questions?
Absolutely. So when it comes to the Q&A portion of either of the panels, the moderator will say so. If you click on the bottom of your screen, there's a participants button. If you click on that button, you'll see on the right side of your screen, a list of participants will show up on the right side. It's quite a long list. On the bottom of that list, there's a button that says raise hand. If you click that button, you'll have the ability to raise your hand, and I will then call on people in the order that their hands are raised, and I will unmute you. You'll be able to answer your question, and then when your question's over, I'll put you back on mute.
Okay. The first panel is going to discuss the impact of COVID-19, the crisis, on the dispute financing industry. The moderator is Maya Steinitz. I'll let her introduce the rest of the panel, but Maya is a professor of law at at Iowa Law School, where she does research on the intersection of civil litigation and corporate law, public and business, international law, transactional dispute resolution, and global legal profession. She's one of the nation's leading experts on dispute finance. Prior to joining the faculty at Iowa Law School, Maya taught at Columbia Law School, Tel Aviv University, and the Hebrew University of Jerusalem. She also clerked for the Honorable Esther Hayut, who's currently the Chief Justice of the Israeli Supreme Court. Maya, I'm going to turn it over to you, and you can introduce your panel.
Great. Thank you very much, Peter, and thank you and David and the Center for putting together this very important and timely panel. We have a panel of esteemed industry leaders and thought leaders in the area. I'm going to introduce them very succinctly in the interest of time, but you should all feel free to give another sentence or two each about your expertise if you wish to do so before we move on to our, as I turn the questions to you the first time that I do it during our round. So again, briefly, we have with us Bernardo Cremidas, who's the founding partner of Cremidas Associados, as well as a senior international arbitrator. We have Julia Gaywalb, I hope I'm pronouncing it correctly, who's the Director of Underwriting at Validity Finance. We have Mark Jacobs, co-founder and president of Arrowhead Capital. We have Professor Richard Painter, who's a professor of law at the University of Minnesota and the former chief White House ethics lawyer. We have, I hope, or will have joining us shortly, Selvin Seidel, who's the founder and CEO of Fullbrook Capital Management. And we have Alan Zimmerman, who's the executive chairman and law counsel of Law Finance Group. And what we're going to do for our panel is we're not going to have presentations. I will be directing a series of questions to the panel. Each panelist or each question will be addressed by anywhere between 1 and 3 of the panelists. We'll do that to keep things dynamic. And after about 60 minutes, we'll turn it over for questions and answers. So our first question that we'd like to address is, what are the emerging effects of the pandemic on law firms? We need to understand that before we can understand how it affects litigation finance. And so I turn this question first to Alan Zimmerman. And again, Alan and anybody else, the first time you're speaking, if you want to give a little bit more background about yourself, feel free to do so.
Okay, great, thanks, Maya. I've been in this business for 26 years, funding litigation with Law Finance Group. I'm always amused when I hear people like Peter describe it as an industry, because when we get started, I got started, you could put everybody in the quote industry in one elevator, a small elevator, and it's grown, and it's for good reasons. And that really gets into the issue of why we're here today. You know, law firms and the civil litigation system is aside from its legal aspect and its process aspect, costs a lot of money. It's an economic adventure to get involved in a lawsuit in America, and it's a multi-year, in many cases, multi-million-dollar experience. What you have today is you have a dislocation, economic dislocation, and physical dislocation of law firms, of clients, and the courts themselves. We're not having, if you're a litigator, there is no trials going on anywhere I know in America, and some states are very aspirational now and saying they're going to be opening up courts for trials in June and July and what have you. We'll see what that looks like. But and at the same time, when they do that, in most jurisdictions, criminal cases get a priority over civil cases. So when we're going to see cases getting resolved in America is very uncertain. In the meantime, you've got clients who are in economic distress and concerned about it, and law firms themselves are not highly capitalized businesses. So where does the money come from to pay for all of this? And if somebody's got a claim, how is it provided? And one of the good things is this quote industry, as Peter describes it, has developed and has grown and there is capital available for good cases and good law firms to supplement the economic dislocation of the clients themselves. And we'll talk later about the impact of these other dislocations on how funders look at this from the standpoint of how do we address this and making money available to clients.
Thank you, Alan. Professor Richard Painter, you're next, and feel free to tell us a little bit more about yourself, but also your thoughts about how that crisis is affecting law firms and likely to affect firms in the foreseeable future.
Well, I have had a lot of my experience before I went into law teaching in law practice and securities litigation, corporate transactional work. And one of the things I've noticed, though, through my time as a law professor is how much legal work has been outsourced already over this past several decades. I believe we're going to be seeing more and more of that. And the COVID-19 crisis has shown us what can be done remotely. And we're being pushed to the limits as to how much can be done remotely. And a lot of law firms may be rethinking large physical presence in various offices in cities around the country, around the world. I've noticed that my law students are getting very used to Zoom meetings. I have a securities litigation class where we had a mock securities litigation exercise with a motion to dismiss. I played the role of the judge, and I believe the students on Zoom were actually better than students I'd ever had before in the classroom. Maybe there's a very good group of students, but people are adapting very quickly. And the question is going to be how much law practice remains the same, goes back to the way it was before COVID-19, or how much we perhaps are learning from this, that there's a lot we can do more efficiently. People are talking about recording more lectures for large law school classes that you could use year after year, and then the professors actually spend their time talking to the students one-on-one or in small groups. There's a lot of rethinking of legal education and whether we've been doing it the most efficient way possible. So this is certainly a sea change for the legal profession, for legal, for academia, and we'll see what comes out of this. Certainly in litigation finance, the upside here is that I think people are very open to new ways of thinking, new ways of practicing law. New ways of coordinating work, whether online or wherever, remotely. And I think the open-mindedness that hopefully is going to emerge from this crisis will also be an open-mindedness with respect to how lawsuits are funded and the need to bring in financing for the plaintiff side that matches the enormous amount of money out there that can fund the defense of lawsuits from the corporate side. So I look forward to the rest of this conference.
Thank you. Mark Jacobs, do you have any thoughts for us about how the crisis is going to affect law firms in the foreseeable future to you?
Yeah, I mean, I think you're going to see a number of things happen, and some of them are conflicting. I think number one, law firms have probably already realized that they may not need the massive amounts of very expensive real estate that they have. That as the associate bodies and the partners and of counsel become more adept at events and processes like Zoom, people are going to say, why do I need to pay $1,000 a square foot for Midtown Manhattan office space? Putting aside the health issues of having to get on a train or a subway or a bus to get to that $1,000 a square foot space. So I think that's already happening. One of the conflicting sides of that is that I think and this may be an opportunity, it's going to be difficult to train young associates unless you've got them organized in such a way that you can effectively do it. And then, of course, you're going to have the problem, and just on the litigation front, you're going to have the problem of how do you conduct the cases. My partners and I were on the phone this morning talking about how difficult it is, for example, to take depositions or to cross-examine people remotely, and to coordinate things like documents if you're using exhibits. So I think all of these things are fair game. I'm an optimist about this, and I think that this will open up burgeoning new opportunities, not just for litigation funders, but for all kinds of law firm service providers. But it's not going to be a smooth road. It's going to be a bumpy road. I would not be surprised to see a significant number of law firms fail for a variety of reasons. Some of them financial, some of them management oriented. And I think that, I don't know what's going to happen in terms of clients, what kind of pushback we're going to get to constantly increasing hourly rates when in fact you're going to ratchet down some of the underlying rationale for that. So there's clearly going to be a lot of change. I don't really expect that law practice, maybe this holds true for most service businesses, I don't think you're going to see a snapback to the way it was pre-COVID-19. I think you're going to see a forward progression. And I think that the bottom line of the pandemic is, I think it's dragged technology forward 10 or 15 or maybe 20 years. We're now doing and contemplating doing things that we probably would not have thought about doing for quite a while into the future. So.
Thank you, Mark. So as the pandemic is dragging a somewhat conservative profession, conservative in terms of not super eager to change, courts have, according to some people, been even more conservative about changing the way we've been doing things, sometimes for a millennium. So the next question to our panelists is, how is the pandemic affecting and going to continue to affect the forms in which our clients litigate? So that would be courts and international arbitration forum, maybe other arbitral forums. So for that question, I'd like to turn first to Julia.
Sure, thanks, Maya. So, I think an interesting point here is a lot of what we just talked about in terms of how law firms are going to adapt. It's going to depend on what courts do too, because if courts continue to require in-person hearings, if paper exhibits, are necessary, law firms are going to need staff physically present in offices to put that stuff together. So to some extent, these go hand in hand. There's been a little bit of talk about whether this pandemic has shown that current processes and procedures in civil cases need to be streamlined or need to be made more efficient. I would be surprised if we saw some real fundamental changes to the civil rules coming out of this. For one thing, those take a lot of time to be considered and adopted. And by then, hopefully, we'll be more or less back to normal. But what I would expect to see, and what I hope to see, is that courts coming out of this take a sort of disaster planning and preparedness point of view, study the lessons learned from this, come up with best practices and implement those. Because I think a lot of times here, the delay has been that courts are struggling to figure out how to adapt and are taking time to put those processes in place. And next time, if they're more prepared, we may be able to sort of handle things more efficiently. The obvious change in the courts right now are delays. I think across the board, just about every civil case is experiencing delays. I think once things get back up and running, that may continue depending on the specific orders in place in whatever jurisdiction you're talking about. But if I were a defendant, I'd be wary of pushing too hard on that, of asking for too many extensions. I think judges are going to have considerable backlogs, and their patience may start wearing thin, and they may be sort of less generous in granting extensions they might once have granted. And then the bigger question, of course, is what is going to happen to court procedures, what's going to happen in depositions, what's going to happen in hearings and trials. There's been at least one instance of a court trying to conduct a jury trial remotely. It's a real guinea pig for the whole system. In other cases, other courts have conducted bench trials remotely, and so I think courts are starting to warm up a little bit to that. But I think it's a challenge for the parties. I think that the human dynamics in the room are different. It's harder to read the room, so to speak. It's harder to react on your feet. In some cases, handling of physical evidence or demonstratives are very important, and that's harder to do over Zoom too. And then, of course, in the case of depositions, if you have to ship your documents overnight to the witness in advance, it's harder to surprise them in the middle of questioning. So there are some pros and benefits that parties are going to have to weigh. But I think at the end of the day, a party who's going to confront the question of, well, do I want to wait 6 months for this deposition in person or 6 months for this hearing, or am I willing to live with doing it remotely? I think parties are starting to come around to finding ways to adapt to doing things a little bit more remotely.
Thank you, Julia. So you're problematizing for us the issue of whether the new technologies are necessarily bring efficiencies to the process, which has always been the problem, or the promise, sorry, at least in the short term as we adjust. And you've mentioned to us some of the stresses that are being placed on our court hearings or in-person processes, and that's a perfect segue to talking a little bit about changes that are maybe coming to international arbitration, and I hope that Bernardo can help us think through those.
Yes, I think when the COVID-19 started to be around, we thought that we had to adapt ourselves to the new situation. And it was very quickly the way we readapted to that situation. In the international arbitration, the question is, are we really facing a new age of advocacy? In the sense that we are organizing many hearings on a virtual base, and the arbitrators cannot stay 4, 5, 6 hours before the screen. And that's going to change the way advocacy is going to be presented, because if you want to convince the arbitrators, you need to speak, go right to the point. As you know, we have 2 phases in the international arbitration. One is the written phase and the other one is the oral phase. Probably the common law trained lawyers are more used to the oral phase. To the contrary, in the continental civil countries, we are more used to the civil, to the written phase of the proceedings. My impression is that is going to change the balance we had at the present situation, in the sense that it's going to be more important the written phase than the oral one, and the oral one has to be concentrated to convince the arbitrators, and you cannot make long pleadings, long cross-examinations. You cannot present thousands of documents the way we've done at the present situation. Now we are readapting ourselves to that. And I'm convinced that the new technology concerning arbitration is going to develop very quickly. I mean, there are many, someone said before that cross-examination cannot be done through the virtual basis. I'm not so convinced about that. If you see, for instance, a football game, you see on the television probably better than being on place. And I think it's going to have the same with our technology, the multi-screen situation technology, the document production, the way things are going to be dealt. That's going to develop a new technology, and we are going to face that in the future. The question at the end is going to be, what is our client expecting? What are the parties really expecting? Is the party, the client we represent, going to be dissatisfied because they want to be present at the hearing room? Is that technology going to dissatisfy them or not? I mean, that's something to be in the future, but I can tell you that now we have a real revolution in our agendas. Things are changing a lot. Arbitration that we thought it was impossible to be done on a virtual basis because it's very factual case, like the construction cases. Now we see that those hearings are taking place on a remote base, and we are really facing the situation in which time is really better used on a virtual basis than on the physical presence. Think about the conference we are meeting together. If I happen to be present at this meeting, I had to travel from Madrid, Spain to the United States, and it means not only the cost of the travel and the planes, the hotels, but losing probably a week to be present in this conference for 2 hours there. Now we can solve it just on a technological basis. That's going to happen as well in our proceedings, as we have to adapt that cost-saving situation to the clients as well.
Thank you. There's definitely going to be a lot of questions for researchers to think through and research what effects the mediation of the screen has on things like assessing witnesses, presenting evidence, and so forth. Let me take an opportunity here to provide you with a code. Our first code for today is DFL, Dispute Financing Library. That's what it stands for. And the number is 246, DFL 246. Before we move on to the next question, David, can you just let me know? I'm not seeing Selvin Seidel. Has he joined us?
Selvin is on my phone. So if you have a question for him, I can hold my phone up and get an answer, but he's not on the Zoom.
Okay, so this is experiential learning, right? Working with new technology in real time. So let's try and loop Selvin in and see if Selvin can help us with our next question, which is what are the effects of the pandemic and the attendant changes on the ultimate stakeholders, the litigants, the plaintiffs, and the defendants? Selvin?
Selvin, did you hear the question? The question is, what are the effects of the current crisis on the litigants themselves? Do you have any thoughts?
Several. One is that they're going to have many more claims because of Brexit and because of the wider use of claims of this particular method of linking up. So there's going to be more claims. They'll be easier to process because the network of emails will allow, and Zoom will allow them to process it more cheaply, and therefore there's going to be a great influx of claims that are going to be registered for use by this Zoom or whatever else is connecting people.
Thank you very much. That actually worked. So thank you. Alan, do you have some thoughts for us about the litigants, plaintiffs, defendants? How are they going to be affected by these changes? We're not going to snap back, we're told. What's in the future for the litigants?
Well, I have several thoughts, and some were triggered by the comments that Julia and Mark made. I think the cost of the civil justice system, this could be a catalyst, I should say that, a very strong catalyst for making the system much more efficient and less costly. Why do I say that? First of all, virtually all hearings that are done in courts or have been are in a courtroom. Every judge gets a courtroom. And so they have to build courts for the judge to have a courtroom. I don't think you're going to need to have a courtroom unless you have a trial in most cases. There's no reason why motions couldn't be heard virtually. There's no reasons why, even in criminal cases, defendants can't plead in a virtual session. So I think you can see the cost of the system going down to the extent that law firms themselves are able to be more efficient by not having to everybody get in their car or their train or wherever it is every day and drive to a central location and get into an elevator and go up to the 10th floor of a very, very expensive piece of real estate in order to conduct their business every day. Is going to drive down the cost of running a law firm, I think. And the competition among law firms, I think, is going to drive down overall the cost of lawyers. And one of the things that I've seen in our looking at the cases we have is that clients are themselves right now are in distress, and they're looking for ways to save money in using legal services. And one of the things they're doing is instead of going to the central New York, Boston, LA markets, Chicago, where the rates are 4 figures per hour, they're going to smaller cities where they can get the same lawyers who went to the same law schools and had the same training, and they can pay half the percentage. I live in Texas. I can tell you the hourly rate of a Texas lawyer who's actually trained is about half of what it is in New York. And they're living well. They're not starving, I can assure you. But everything is less expensive. And I think clients are going to start looking for that as well. You cannot, there gets to be a ceiling on how much money people are willing to pay and have the ability to pay to resolve cases. And to some degree, what you do in the litigation finance business, the more expensive the cost of the lawyer is, the bigger the case has to be for you to even get involved, because there always has to be enough money left over for the client and or the lawyer. So I think you're going to see some pressure overall on the overall cost of the civil justice system. Well, this could be a catalyst for that, and I hope it is, because it's getting to the point where we're without litigation financing, and I'm not just speaking against my own economic interest, but I think there's going to be plenty of opportunities for litigation financing, plenty. How big a bite you have to take to get involved in a lawsuit is going to diminish to some degree as a result of this.
So, Richard, I'm eager to hear your thoughts next on the effects on litigants, and feel free to address anything in this area, but I wonder if you have thoughts about two things specifically. One is we kind of hear cyclically, especially when we have crises, that there's going to be pressure on pricing, clients are going to finally have a better bargaining position. Do you think that moment is finally upon us, or is that going to elude us after this crisis as well? And another question for you is, do you think there's going to be questions about the legitimacy of the process? Are litigants going to accept a judgment that's rendered without them being physically present in a courtroom?
Well, I'll start with your second question. And in civil litigation, I believe a lot can be done without being physically present in the courtroom. The trial, however, I believe should be conducted in a courtroom, whether it's a judge trial or a jury trial, because the credibility of witnesses is important, and it's important for the judge or the jury to see the witnesses as they testify and judge their demeanor. I believe all that is important, but we all know that the vast majority of activity that takes place in courtrooms is not trials, it's preliminary motions and the rest of it. And we can clear all that out. And depositions as well need not be conducted in person. I've been testify as an expert in many depositions in person, and the hassle of people getting on airplanes and running the room and all the rest of it. We can avoid that. So I do see enormous cost savings that can be accomplished without compromising the integrity of the process, just as long as we use good judgment. And judges are going to be supervising this, obviously, along the way to make sure that due process is upheld. Is this temporary? Are we going to go back to business as normal? I don't know, but there's enormous price pressure in the legal profession right now. And I analogize it to what's going on in academia, and I've had discussions here at the University of Minnesota about how we can be a lot more efficient in universities and delivering education, because that's another area where costs are extremely high, higher in the United States than in any other country of the world. And our students, of course, pay for it with their debt. And there's a lot we can do to be a lot more efficient. We're learning that through the COVID-19 crisis, how much we can do online. My favorite is the online faculty meeting that I can just go in and out of as I see fit. I just love that. I just got to make sure to use that mute button if I'm signing out. But I just believe there's enormous efficiency here that can be obtained in many industries. Education is one, and the legal profession is another. And the price pressure is there. People are sick and tired of having to pay so much for lawyers. And this is the very, very good news for the litigation finance industry. When we bring costs down on the plaintiff side, particularly when we bring costs down, we could bring down the cost of financing, have more people willing to invest in lawsuits, pool lawsuits together. There are a lot more opportunities to balance, to restore the balance of power between plaintiff and defendant that I believe has been distorted by the enormous amount of money on the corporate side for the defense of litigation, and great difficulties with the financing side for the plaintiffs. And so I believe we can restore a balance of power. That ultimately will do a lot for the integrity of our justice system.
Thank you. And you mentioned the cost of higher education. of legal education. Of course, there's a relationship between that and what lawyers charge, because a lot of lawyers will say we have to charge the high rates in order to pay back our student loans. So if there's kind of downward pressure on the price of legal education, that may in itself have an effect on how much lawyers feel they need to charge, especially for junior lawyers. That brings us around at the half-hour mark to our main question of the day. We've set up the predicates. How is the pandemic going to affect law firms, courts, international arbitration, and other fora, and the litigants themselves? And now we can get to perhaps our main question. How is it going to affect litigation finance itself? And so I want to maybe break it up into two. We'll start by talking about how is all of these changes going to affect the financing of a single litigation, if the panelists can address that. And then I'll prompt you to address whether it's going to change the litigation finance industry more broadly. So Mark, I turn this first to you, the first of these two questions. What changes, if any, are we going to see to the way that financing is conducted at the level of an individual case?
Well, I think the one thing you can probably rest assured of is that it's going to become more expensive. The inherent delays, which I think Julia and other people have pointed to, that are likely to come out of having to litigate remotely, is going to increase the cost of litigation funding. Our cost structures, and I think this is true for the entire industry, at least on the commercial side, the entire cost structure has a time-based element. So the longer it takes to resolve a case, the longer it looks like it's going to take to resolve a case, the more expensive the funding is going to become. So I think that's the one thing you can rest assured of. It's going to make underwriting somewhat more difficult because there's going to be, I think there's likely to be much less face-to-face encounters with the key players in any litigation, be it the lawyers or the litigants or the witnesses. We have yet to see what what kind of changes there are going to be in the judicial system. Whether this is going to, really adversely impact things like jury trials and civil litigation, and if so, how? I think Julia made mention of the remote jury trial. As a guinea pig, that's about the most generous description I think you could find for it. But I do think people are going to try to figure out ways to make this work. But I think the one thing you can rely on is that part of it's going to get more expensive. The lawyers may get cheaper, but litigation funding, I think, is going to get more dear.
Thank you. Julia, I want to turn this next to you. I'm interested in any thoughts you have on how all of this is going to affect the funding at the level of the individual case, but I think our audience would probably be particularly interested in whether you agree that litigation finance is going to become more expensive. It's not necessarily the intuitive kind of judgment call on that. So what do you think?
Yeah, so I agree with most of what Mark said. I mean, in terms of the underwriting on a very basic level, we typically try to meet the funded person before we enter into a multi-million-dollar agreement with them. And we do that by Zoom now. And so that's already gotten a little harder. In terms of pricing, I don't know if Mark meant that funders' rates or terms would broadly go up, or if at the end of the day, litigants will pay more under existing agreements, because most funding agreements already account for delays and for the time until the funder gets returned, and usually have an escalating return.
Yeah, I'm not sure
anyway.
that I agree with you. I think what it means in reality is that because things are going to take longer, the ultimate return to the funders is going to be higher. I didn't mean that, overall that structure would change.
Right, that's sort of what I thought you had intended to say. So, funders have already priced in delays. And so I agree with Mark that to the extent things are getting delayed, at the end of the day, that higher pricing period is going to kick in because it's going to take longer to resolve. And other than that, I think litigation funding has always been a solution for uncertainty, risk, and liquidity for businesses. This is no different. I just think that this pandemic and the economic situation businesses are facing are highlighting a lot of that value that funders provide. And so, I think the typical products we usually provide, single case funding, portfolio funding, the pricing structures, they're all meant to address the problems we're seeing right now already. It's just that the problems are even more magnified than typical.
Thank you. Bernardo, what do you think of the question of how all of this is going to affect the funding of an individual case? Again, any thoughts you have on that? But if you have a particular insight on international arbitration cases.
Well, my impression listening to Julia and Mark is that you are thinking in terms of that virtual is going to delay, and that's the reason why it's going to be more costly. That's not my impression in international arbitration. To the contrary, I am very optimistic in the sense that things are going to be quicker and probably smoother, so that the price is not going up. To the contrary, it could go down. I mean, probably in the international arena, a lot is being done on a written phase. And on the written phase, you are not expending that much. My impression is that attending sometimes to important arbitration cases in the hearing, you see sitting around 100, 120 lawyers, and they charge just sitting around weeks, and that's going to disappear on the virtual basis. So my impression is that we have to change in the international arbitration the way we are conducting the business, and very probably to the contrary what Julia and Mark have said, I'm very optimistic about getting things quicker and reducing costs.
Thank you. It's always good when there's opinions going in different directions on a panel. David, are you there, and can you patch us to Salvan?
I certainly can.
Okay, I'm very curious to hear what Salvan thinks about this question. Is the economics of the individual case going to change? Is it going to get more expensive, less expensive, or is there some other changes at the level of the funding of an individual case?
Salvan, I don't know if you heard the question, but it's whether you think the pricing is going to change, whether things are going to get more or less expensive on the level of an individual case for funding.
I think unlike some of the things I've heard, that the prices will go down and business will go up. I think that the elimination of travel costs, of office space, of a lot of things will decrease the cost of funding and will increase the productivity of it. We can go down individual industries like the hotel industry, like the restaurants, like the office space, to all confirm what I think is going to be the case.
Thank you, Salvan. And Alan, can you weigh in on the million-dollar question, no pun intended? Is it going to be more or less expensive, do you think, to fund a single case?
I don't think.
Are we asking the wrong question? Is it really about different types of cases, right? Bernardo is giving us a differentiation there between international and domestic.
I think it's going to have an impact on the size of the cases that funders want to fund. I mean, there's a metric that exists right now between how much money the case is going to cost, that is how much money in attorney's fees, assuming that the money is used to pay the attorney's fees, which is not always the case. But let's say the purpose of the funding is to fund the attorney's costs in the case. And if the cases are going to extend out, let's say 5 years, the funder is looking for a return on the money. They get their money. They don't print the money. They get it from other sources typically, and those people want what they call an IRR, a return on their money, an internal rate of return. And the longer the case goes out, the more money is going to cost. The dollar amount is going to go up. So if I'm looking at a case, or anybody in here is looking at a case and is saying, okay, if it's going to cost $4 million in attorney's fees, and now I'm looking at a 5-year case, and instead of it being 2 times or 2.5 times, it's going to be maybe 3 or 3.5 times. Well, that's $12 or $13 million that the funder is going to want to get. Now, how many cases can absorb $13 million in funding and he have something left over for the lawyer and the client in addition to that? So the more there's going to be, either the cost of litigation is going to go down, in which case it's easier then to fund at a smaller bite size, if you will. But if things extend out and nothing else changes, you're going to find that there's going to be a smaller and smaller group of cases that'll be funded, because the length of time it takes the case to resolve through the civil justice system is not likely to impact the dollar amount that's going to be paid at the end of the case. So it will have an impact on the metrics that I'm trying to describe for you here. And I would hope, and I would like to see, if the actual cost of the case goes down, which could be an outcome of this catalyst here, then there'll be more cases available to fund, because there'll be a lower cost of legal fees, less money be put out, but there'll be more cases that can be funded, and it'll be more available to litigants. Right now, if you've got a small case, you're not going to find very many litigation funders who are willing to spend the time and energy to do the due diligence and all the work that goes into it to put out $500,000 or $1 million or even $2 million today. So if the case goes down in value, you're going to find more availability. I mean, if the cost goes down, you're going to find more availability. But I don't think that the actual pricing is going to change much, because the sources of the money want a certain return for their money, and that's where we get our money.
Okay, so that gives us a perfect bridge to asking the questions at the level of the litigation funding industry. And I'm going to turn it first to Richard. Richard, do you think we're going to see changes to the structure of the litigation funding industry? Are we going to see consolidations, fewer larger firms? Are we going to see more competition, more smaller boutiques? Are we going to see maybe new players come into this, banks, insurance companies? What do you think the future holds for the litigation funding industry as such?
A lot of this remains uncertain. Let's focus on the big factors.
Selvin wanted to cut in with one quick thing. Sorry.
Yeah, it relates to the cost of litigation by both the lawyers and the claimants. And I just don't see how the price can go up. It will go down. There won't be office money to spend. There won't be travel money to spend. There won't be various essential costs that are going to go into it. So it's not going to be millions of dollars for a case that runs 5 years. It's going to be, if it runs 5 years, it's going to be unusual. It's going to run more quickly, and it'll cost less, I think.
Thank you, Selvin. So obviously, I mean, big question is, all other things considered, is the similar case going to cost more or less to pursue? And it may be that there's a difference between the short and medium term versus the longer term. We're in the middle of a disruption. Everybody's learning how to do this. Maybe in the short term, things get more expensive, but in the long term, as we kind of iron out the hitches, then it's going to get cheaper. So maybe it's not really a difference of opinion, but professors love debating it both ways. So thank you all. And now, Richard, back to you and your thoughts on how the legal industry, legal funding industry as an industry might change.
Maya, you're exactly right about the distinction between the short term and the long term. The short term is going to be difficult. We have a backlog of civil cases. Criminal cases need to take priority. We have in Minnesota, the courts are pretty much shut down, except for criminal arraignments. And we're going to have to get through all those before we can get to civil cases. And that delay is going to be very frustrating for financiers of litigation, because that's a big factor that investors are interested in. When do I get my money back? And the longer the delay, not only the longer the cost of the money because of the time period, but the higher yield or expected return on investment that investors will expect. We also have uncertainty, and that's something that investors will charge a premium for, with this uncertainty. You can reduce some of that by having a diversified portfolio of cases you invest in. But a lot of this uncertainty short-term is systemic. The question of how much delay there's going to be, how much further delay. Is COVID-19 going to go out of control this fall in October and November, the way the 1918 flu epidemic did? We don't know. And if we were to have a very bad winter, as many of the experts have testified, that Dr. Fauci, others, that there might be a risk, Dr. Bright, well, that's certainly going to put civil litigation way down the road, and people are going to think twice about investing in the summer of 2020. So that's the bad news. But the good news over the long term is that costs can go way down. Plaintiffs' law firms have to be innovative. It's one thing for a big corporate law firm to have the fancy office downtown and continue to charge Goldman Sachs $1,000, whatever it is an hour. Goldman Sachs pays it because their cases are worth billions. Well, then so be it. Things may or may not change. Maybe people want to go back to business as usual. The plaintiffs' law firms have to be innovative, have to save money up front, and this litigation financing costs them. They know it. They're going to do everything they can to reduce their costs up front. The cash flows. And so I believe the plaintiffs' side of the industry is not going to go back to business as usual. We're learning a lot from this pandemic, how to handle electronic communications, meet remotely. And I have to say, this is also very good for the environment to get people off the roads. You should see those maps of the satellite maps of how much CO2 emissions coming out over LA. And you can actually breathe in Los Angeles these days, I'm told. So it's a sea change here. I think plaintiffs' lawyers will lead the way. The industry could lead the way, but it's going to take time. We're going to take this next year or two is going to be very rocky. So I get back to my observation that you were right on the money there, Maya, when you said there's a short term and then there's a long term, and we need to keep our eyes on both and what's going to happen in both phases.
Right, and of course there's uncertainty about when we will officially be at the end of the beginning and be at the beginning of the end, right? Nobody really knows that and can't really time that. Thank you, Richard. Mark, what do you think, gaze into your crystal ball and give us some predictions about your industry as an industry. Is it all going to be the same? Are you going to see changes? What do you think?
Yes. It's all going to be the same, and you're going to see a lot of changes. I think without a doubt, we're already seeing changes. And one of the things that's already happened, at least, and I think this is probably a pretty universal experience on the funding side. We've seen a dramatic uptick in the number of opportunities for funding. Some of it, I think, is that the law firms have realized that they need access to capital that doesn't require their partners to pull out their checkbooks. Some of it is that the litigants are in need of capital, more so than they used to be. So we at least have seen a pretty significant uptick in the number of cases. I think that's likely to continue. I mean, there is, of course, this great uncertainty as to how the pandemic is going to play out. Is there going to be a resurgence come the late autumn? Is it going to disappear? God willing, that would be great. We can all look back on this miserable time and say, well, I'm glad that's over. But I don't think anybody knows with any certainty. And I think we're all struggling to get on with life in the midst of a dramatic increase in uncertainty. So, I think certainly for the foreseeable future, there's going to be an increase in demand for litigation funding. As law firms and litigants look for ways to operate without having to tap resources that they want to use for other things. Beyond that, I mean, I have my crystal ball is as cloudy as everyone else's, I suspect. I hope for the best, and we're pushing along. One other thing we've noticed is that as quickly as we can adapt, there is a significant increase in the amount of friction. that everything takes longer to do than it used to. And that, of course, slows things down. And delay, I think, plays to the benefit of defendants and against the interests of plaintiffs and, by corollary, the interests of funders. So, the sooner we can figure out how we're going to cope with this, the better. And again, being an optimist, I think there's opportunity here. But, I think the reality is there's no way to be in any way certain of what's coming next.
Thank you. So Julia, feel free to either address the question we've already been thinking about. Is your industry as an industry going to change? Are you worried? Are you optimistic? Are you a bit of both? Or you can start telling us about whether you think they're related. You will be putting out new innovative financial products in this area that we haven't seen. One of the recent developments that was all the rage to think about and theorize and so forth before the pandemic was the rise of the funding of litigation portfolios rather than individual cases. Are we going to see some completely different product being put out there? What do you think?
Yeah, thank you. So I think there's a couple of things happening at once. And just to set the backdrop a little, it's interesting to me to take into account the fact that this pandemic, which I think in many ways is demonstrating the value of litigation funding to people who maybe didn't always see it that way, is coming at a time when litigation funding is really becoming normalized in a way it hadn't been before. So there's just this convergence of events. And so I think there's good reason for funders to be optimistic about new opportunities. Just yesterday, Minnesota overturned its common law prohibition against champerty, for example, opening up a whole new state for funders. So I think you're seeing the legal system in general being more open to funding. And then with this unfortunate situation, the ways that funding can serve litigants and counsel are becoming ever more clear. And we're seeing increased demand in a couple of ways. One is, COVID-19 related litigation. That's an obvious one. There's a big uptick in business dispute coverage claims. There's an uptick in force majeure claims. Some law firms, speaking of portfolio funding, even if it's not the litigants themselves looking for funding, some law firms are trying to get a leg up on launching those practice areas and are looking at funding as a way to do that while mitigating the risk of trying to grow in that way. So we're seeing a lot of that happen. And then more generally, I think as businesses, there is this downward price pressure. Businesses facing cash crunches may balk a little bit more at paying fees on an ongoing basis, or just may be unable to do it. I think you may see firms that were traditionally more conservative about these things start thinking about either taking on more risk themselves or looking at funding as a way to bridge the gap. So I think that there are new ways that funding can serve counsel and their clients. Whether we're going to need new products to do it, I think is more of an open question. To date, the single funding and the portfolio, which we've been doing for a long time too, both of those products have basically met the needs of anybody who's come in our way. But that said, our agreements are always bespoke. They're always a little bit flexible, and we sort of always tailor them to the individual needs of the case. So I wouldn't be surprised if we start seeing more flexibility in terms and things like that. But in terms of an outright new product, I don't think we've quite seen the need for that yet. But I wouldn't be surprised.
Thank you. Bernardo, with your law firm leader hat on, rather than your international arbitrator hat on, do you think we're going to see new innovative ways in which law firms and funders partner to conduct the business of civil justice?
Well, Maya, as a matter of fact, you are talking about new instruments of finance. Probably you are focusing in this discussion on domestic issues, and criminal cases are very different from civil cases. And domestic cases are totally different from international cases. In the international arbitration, we are focusing now new ways of finance. For instance, we see a very important secondary market in the sense that awards or even the cases are sold and there is a secondary market, very important. We see a syndicated finance of those cases. Probably we are talking in the international arbitration, big cases, billions of cases, and that's the reason why these new instruments like the secondary market is permitting that. So I think it's now very important when you are facing a finance funder, you have to present possibilities of syndicated and of selling those products. So probably new instruments now in the international arena are taking place.
Thank you. Selvin, do you want to tell us what you think the future holds for your industry and whether we're going to see new ways for funders and law firms to partner together to deliver legal services?
So Selvin, the question was whether what the future holds for the industries and whether funders and law firms, how they're going to work together to provide services.
Well, I think that the law firms and the funders will continue on the same path that they're on now, which is pairing up or forming families, and the two work together well. And I think that the developments we're talking about will only make it easier and better to work together. And I also think that all that's going on is nothing more than something that would have occurred naturally for the most part, because we were going towards technology and Zoom regardless of what's been hurried along through this pandemic. And I don't see this as very much else than an accelerated movement towards what we're going to end up doing anyway.
Thank you. So we're getting near to the 60-minute mark for our panel. So what I'd like to do today, right now, is first.
Can I just add something to that?
Sure. Yes.
I just want to add a little bit to what Julia said, which I 100% agree with, and I won't repeat what she said. But I would say that things are changing already, and there are people coming up with new ideas as to how to provide financing to law firms that may in the past have not needed the financing, or are now worried because of the dislocation in the economic system and their clients of finding ways to fund their law firms and fund litigation. And I think it's accelerating. It's happening now, and it's going to continue to happen. And we may end up going the direction where the UK went years ago, where you could actually have funders owning a piece of a law firm. And that hasn't happened yet, and nobody's talking about it, but it's not, when you think about what the direction we're going, it's certainly not unthinkable, given the fact that our partners in the UK, from which we got our legal system, are already doing it.
Thanks, Alan. So you've given me an opportunity to plug in my forthcoming article, because I'm exactly thinking, and I started actually writing it before the pandemic. I think that for a variety of global trends that are coalescing in interesting ways, we've already been seeing, or there's reason to believe that the next phase is that the US may need to seriously, the states, change the rules about outside ownership and how to carefully and gradually move in that direction responsibly. And I think that the pandemic is going to accelerate it. So stay tuned to my next article. So thank you for that. But we are, I'm sure our audience would love to ask and present us with some questions. So before I launch the Q&A part of our conversation, I would like to give you another code. So please get your pen and legal writing pads. The next code is DFL 315. DFL 315. So for this part of the panel, I'm going to ask David to assist me with calling the queue.
So if you would like to ask a question, I think I mentioned this at the beginning, click on the participants button at the bottom. And then on the right side, you'll see a list of participants. At the bottom of that, you should see a button that says raise hand. So if you have any questions, please click that raise hand button and I'll be able to call on you. Right now, I have Alan Daniel with a hand up, and so I'm going to unmute you.
So
Alan, go ahead.
Hey, good afternoon, everyone. My question is for Alan Zimmerman and maybe Tony Seebach. I read Tony's recent article about transparency and pricing on the third-party litigant funding. And so I'm just curious about price. Alan, you talked about internal rate of returns of your capital providers, and I feel like there's more liquidity and capital coming into this segment. Tony just wrote a very good 45-page article about transparency on the effective rate of pricing on the consumer side. But do you guys think that we're going to see pricing come down as more liquidity flows into the market and more institutional investors get into this space?
Thanks, Alan. I would say a couple of things. First of all, one of the things we haven't said, which is fundamental to the economics of being in this business and investors, is that this is not correlated to anything else. If the stock market goes down 20%, the value of our cases and our investments are not materially affected. If the price of oil goes down, it's not materially affected. Investors right now, in the tremendous amount of uncertainty and dislocation, are looking for places to put their money that are not correlated with the stock market, with companies that have experience doing this and a track record, so they feel comfortable parking some of their money in a place where they hope it's not going to be impacted by the types of things that we've had with COVID. I think just the laws of economics tell me that supply and demand, sooner or later, the prices are going to go down because more money will be chasing these opportunities for investment. So I think probably just if you just follow the laws of economics, it will. If I'm correct and other peoples are correct that this could be a catalyst for reducing the cost of litigation, that is the attorney's fees and the complexity of the litigation and the cost of getting on airplanes and the like, then you're going to see additional savings. So I think ultimately on the long run, yes, I think there's a pressure to do that. Whether it does or not, we'll find out. But I would think so.
Can I speak to that for a second, Maya? Because I have a contrarian view on this.
Sure. Oh, contrary, especially if it's contrary, and then we'll let Tony chime in if he wants to.
It has to do with a couple of things. Number one is that investing in litigation is essentially early stage venture capital. And what you are looking at is extremely high risk investment. And we've gone around and around about this stuff in our own shop. It doesn't matter how much money comes into this sector as an investment, it doesn't change the risk of the cases. And when you look at the risk of the cases, the investors who are putting their money up and they say, you're going to win 1 of 3, you're going to win 1 of 4, you're going to have a small group of, you're going to have a group of singles, you're going to have a smaller group of doubles, a smaller group yet of triples, never mind anything beyond that. So that if it drives pricing down, I think it could very well, it'll do long-term harm, frankly, to the industry, because investors will then say, I'm not getting a return that's commensurate with the risk that I'm taking. And I also think that there are some, and maybe they're peripheral, but there are some flaws with the completely uncorrelated argument. And I think that the COVID situation has kind of underscored them. One of the things that we look at when we underwrite a case is collectability. And I am more concerned now with the ability of defendants to pay a judgment or fund a settlement than I was 3 months ago. I think that there is a massive economic and financial dislocation underway. There are going to be just a raft of bankruptcies. And a lot of the outcome of those bankruptcies is going to be no payment to anybody on anything. There's just not going to be anything left. So I think to that extent, our industry is not, we may be uncorrelated to the stock market and the price of oil, but I don't think we're uncorrelated to overall economic and financial conditions. And I think we at least are trying to be very cautious about this, and we've always been cognizant of collectability problems, and there's a variety of those. But we really have brought them to the fore in the current economic and financial situation.
Thank you.
Richard Painter
Yeah.
here.
Oh, Richard, please, yes.
Yes, I think one thing that's going to help a lot with respect to risk is if litigation finance funds can diversify. And funds could be specialized in specific areas, such as international arbitration or securities litigation, have environmental litigation, have an area that they specialize in, but then diversify across an array of cases. Use an example of a matter that's obviously of great concern right now in Minnesota, where champerty has just been abolished as a common law doctrine by our Supreme Court. I would not be surprised to see litigation finance firms set up a fund to litigate police brutality cases. Police brutality cases, a large number of them are dismissed and there's very little recovery. But when there is recovery, there is very, very large recovery. We've seen this certainly in the city of New York. And that's an area where if you have a broad portfolio of cases that you're financing, that you could very well have a return on investment, and of course also be doing some good for our society to advance the rule of law. And that's the type of a fund, and they call it a code blue fund or whatever, to fund those types of cases that might very well attract investors who have an interest in monetary return, but also holding people to account. And you'd have people who understood those cases, who know how to fund and advance each case. Of course, you have all the conflicts of interest that we've all talked about and all the problems in those arrangements. But you can reduce risk by specializing in particular areas and yet having a significant number of cases across the portfolio in an area where the investors actually understand the substantive area of the law and the likelihood of recovery and the ideal strategy.
So
Thank you. And Professor Anthony Seebach, who's another thought leader in this area.
So I just want to briefly respond to some of the lingering questions that were asked in the following way. First of all, as a matter of just empirical fact, or a matter of what I discovered in my research, and some of it is very, very large numbers that have been run through a statistical modeling program, and some of it is anecdotal. And I think here Eric Schiller can also chime in, and maybe Alan as well. But maybe the coverage of the consumer market was skewed by hostile newspaper reporters for the last 25, 30 years, but I don't think so. I do think that the pinprick of information that you get when you sort of do a slice through reporting about the consumer market over the last 30 years reveals that prices have gone down over the last 30 years. I mean, certainly, I don't think it's just hostile newspaper reporters reporting on 180% and 210% contracts that were floating around in the 1990s. I think there was actually a way in which the early unmature industry had some wide variation, and maybe just a kind of a median cost that was very, very high. But we do know that we don't see numbers like that probably in any of the major consumer providers. And I think the reason for that is the sort of very boring operation of the marketplace, increased competition and increased transparency on pricing, not because of anything that the state has done, but just because it's less expensive than ever before to use information tools such as the internet to get some kind of comparison on pricing, and there are more entrants. So we've seen, I think, a major decline in consumer pricing. Now, I don't think you can say anything like that about the commercial sector. And on the commercial sector, I just want to observe 2 points that were made and emphasize them. One is, and this is something which Mark said, I think that in the short term, any industry, whether it's factoring or lending on a recourse basis, any industry
that is facing credit risk is going to be facing a big credit risk for the next 18 months, because there's just simply going to be fewer and fewer people able to actually deliver the obligations that they promised. So that's true about this industry too, something unique about that. The second is something which Alan said. I think that where you might see commercial being able to sustain its current margins is if there is greater use of the funder's ability to maximize the recovery for everybody. So, there's going to be greater competition on the part of funders to demand less from the counterparty to take a little bit less and get the contract. But if one funder can come in and say, listen, I can help you maximize your recovery, let's keep X where it was, but I'm going to help you keep more of your recovery compared to my competitor, then I think you might see margins staying the same, even though there is increased competition. And I just think we should talk a little bit about what happens when it becomes more acceptable for funders to get actively involved in the management of litigation.
Thank you. David, do we have time for one more question?
Yeah, I think we have time for one more. If you can either raise your hand under the participants tab, or if you can't figure that out, if you click chat at the bottom and just want to chat in the question, feel free. The floor is open for one more, but we'll see if there is another. Anybody? I don't see any others for right now.
Maybe we've exhausted everybody. there is Zoom fatigue.
So I wanted to, let's see if I can actually do this. Hold on. There we go. That's my way. Thank you, Maya.
Thank you to all the panelists.
And the panelists. I was going to say thank you and the panelists for this absolutely terrific presentation. And, I certainly learned a lot from it, and I'm sure the rest of the audience did as well.